Hello everyone. This is a lecture about European law and its place within English law. Anyway, so I said a little bit of this yesterday, how the European Union used to be the European Economic Community and was founded in 1957. The United Kingdom joined the EU in 1973 and left in 2020. But anyway, a lot of these European laws still remain on the statute book. The United Kingdom is still abiding by all the regulations and trading with the EU as though it were in the EU. That's meant to end at the end of December 2020. What's going to happen after that we don't know, because the long-term arrangements have not yet been negotiated. So at the moment, I think the most likely scenario is probably to extend the current arrangements. The EU not having any British people in the European Parliament, or any British judge at the European Court of Justice in Luxembourg, but the UK is still abiding by all these regulations until a long-term arrangement is arrived at, and the UK will carry on paying some contribution. So anyway, the United Kingdom is abiding by these European laws, and a leading case on European law having supremacy over British law would be R and Secretary of State for Transport ex parte Factor Tame number 2, 1991. It was all to do with the Merchant Shipping Act, which is passed by Parliament but contravened European law in the 1980s. And Factor Tame was a Spanish fishing vessel, and there are a number of cases about this, but the long and the short of it is that it established that EU law definitely takes precedence over national law. In the United Kingdom, other member states, the UK is no longer a member of the EU, but European Union laws remain on the statute book in the UK unless they're specifically repealed. So the European Union as such was set up by the Treaty on European Union, TEU, as it's sometimes known for short, the Treaty of Maastricht, people sometimes call it, since it was signed at Maastricht in the Netherlands. So although this treaty was signed there then, the European Union as such only came into being in 1993. So more reforms were introduced over time. Famously, there was the Treaty of Lisbon in 2007. Originally, there was a European Constitution, but that was defeated by referenda in the Netherlands and France. Therefore, they changed it slightly, the Treaty of the proposed European Constitution, and renamed it the Treaty of Lisbon, and that got through. Of course, the Republic of Ireland, we voted against that in a referendum first time. We were given certain assurances and voted for it a year later. So the Treaty of Lisbon, famously, which specifically granted every member state the right to withdraw from the European Union at any time, and that was going to be a sop to Eurosceptic opinion. And the United Kingdom held that referendum in 2016, in which 52% of people voted to leave the EU, and the UK is the first member state to invoke its right to withdraw from the European Union. So these Europhiles were hoisted on their own petard. Anyway, there's also the Treaty on the Functioning of the European Union. There's a Treaty of Rome which founded the EU in 1957, but it's been updated in the Treaty on the Functioning of the European Union. Part of the preamble of the Treaty of Rome, which is so often quoted, is ever closer union of the peoples of Europe. People often just say ever closer union. I know Eurosceptics, if they didn't actually want to leave the EU, but just wanted to limit its growth, said ever closer union of the peoples, not of the states. But perhaps that's quibbling. Anyway, so the UK initiated its withdrawal process and is half out at the moment. So, but the EU law is part of the English legal system for the foreseeable future. The Treaty on the European Union and the Treaty on the Functioning of the European Union are the chief sources of EU law. So TFEU for short, Treaty on the Functioning of the European Union. This grants certain powers to institutions of the EU to undertake certain tasks, including creating secondary legislation. This secondary legislation is yet another source of law. So this power can be exercised by this principle of conferral, which is spelled out in the Treaty on European Union, or TEU. And it says that the EU can only act within the competences which have been granted to it. So competence is saying that you are allowed to do this or not to do that. Okay, so we know that there are various things that the EU does to make member states obey its laws. The TFEU says that to exercise the union's competences, the institutions shall adopt regulations, directives, decisions, recommendations, and opinions. So let me go on to these. The regulations. These are said to be legislation, and they are adopted using a legislative process. That's different to directives. Anyway, regulations are directly applicable in legal systems of member states, immediately apply throughout the whole EU. Now, coming on to directives, these are also legislation. However, member states have to meet a certain standard, achieve a certain result by a deadline. So these are transposed into national law. What the UK often did was gold plating. So the EU says you must reach this standard. You can go above that standard, but you can't fail to reach the standard. So the people often say, "Oh, these EU regulations are so difficult." Now the Europhile defence was, well, that's because we went further with we needed to. Why it might seem unduly onerous. For instance, there's the Consumer Protection Directive of 1987, Consumer Protection Act of 1987, and that's pursuant to Directive 85/374 on product liability. So it's called 85/374 because in 1985 the directive was issued saying by the end of 1987 you have to reach this certain standard on product liability. So it's the 374th such directive in the year 1985. That's what it's known as 85/374. And there are other ones. There's Directive 93/13 or Unfair Terms in Consumer Contracts, which the UK came to be the Unfair Terms and Consumer Contracts Regulations, 1991. So, and there's a Consumer Rights Act 2015, which has updated it. So a lot of legislation going through Parliament is really simply putting EU directives into British domestic law. And I do say British because obviously it's not just for England and Wales, it's for Northern Ireland and Scotland too. Because the United Kingdom is a member state, the whole of the UK. Obviously not just England, or not England and Wales. Right, so what else? So an individual must be able to rely on the rights conferred upon him by the EU, and if an EU member state fails to transpose this into national law by a deadline, it will pay a penalty. We might be cut off quite soon. So the European Court of Justice has created mechanisms whereby a natural person can rely on these directives on themselves in national courts, even if the member state has failed to implement the directive correctly. There are decisions of the EU. This is another category of law, and decisions are binding on whoever they are addressed to one member state, to some other body of people. And again, these can be enforced in the courts of a member state. So case law, there's some important case laws of the EU, and this has been crucial in developing EU law. And the principles that we find here, they allow a person to assert his rights under EU law in the courts of his or her member state. Instead of EU law, we say his, him, he, and it being understood, this also means the female pronoun. We don't all say he or she. Do you want me to say she sometimes, just for the sake of it? If I say she, I also mean he. Anyway, there are various institutions of the EU. There's the European Commission, which has its headquarters in Brussels. There's one commissioner for each member state, but each commissioner has got a different area of responsibility, as in foreign affairs or education or health or transport, something like that. They're not to represent the member state, and they're to do their duties in an impartial manner for the good of the entire union. So the Commission has a number of functions, and one of these is to come up with legislation to propose it. Then there's the Council of the European Union. This usually meets in Brussels, and it's from ministers from the various member states. So they will call all, let's say, agriculture ministers, or all education ministers, or all finance ministers, whatever the issue is to be discussed. So the council approves legislation and proposals before they can become law. It can, of course, stop these proposals, say no, vote them down, or indeed it can amend them. There's the European Parliament. Members of the European Parliament, MEPs, are elected by people in the member states, and so they meet. They go back and forth between Brussels and Strasbourg. Strasbourg being in France, huge waste of money, I know, but it's to keep the French happy, and also because Brussels is the capital of the European Union, Why is Brussels the capital? Well, nobody feels threatened by Belgium. When the EEC, as it was then, set up, there were 6 member states: France, the Netherlands, Luxembourg, Belgium, Italy, and West Germany, because Germany was divided 1945 to 1990, but that's another story. And if we can't put it in France, it's too big, too mighty. People say it's French mastery. We can't put it in Italian. They say it's a new Roman Empire. We can't put it in West Germany because people are quite hostile towards the Germans. We'll put them in Belgium. Nobody says the Belgians are trying to lord it over us. It's a trilingual country as well. Anyway, so the European Parliament cannot suggest legislation, which the Council can. So, but it approves it. And when the Commission has proposed, and there's obviously a chairman of the European Commission, the Parliament can accept or reject the entire list. They can't reject certain individual members, and they once exercised that right. They reject the entire list because they didn't like one of the Italian nominees because of his views on homosexuality. Some people say that was good. They're flexing their muscles. The legislature standing up to the executive. But representation in the European Parliament is grossly disproportionate. Malta per capita has 15 times more representation than the United Kingdom had. France and Germany also hugely underrepresented. So it's very much slanted towards the smaller member states. Let's look at the Court of Justice of the European Union, or the European Court of Justice. Some call it ECJ. You could call it CJEU. If you think that's confusing, well, it is. So it's based in Luxembourg. And anyway, the Court of Justice has one judge from each member state, but again, they're to do their duties in an even-handed manner. They're not to be fighting the corner of their member state. And then it has 8 advocates general. The judges and the advocates general serve a 6-year term, and these people are many people of most unimpeachable integrity, and they must be capable of holding the highest judicial office in their member state. So the advocates general, they provide a reasoned opinion for the Court of Justice when there are submissions made to them by the disputants in a case. So their opinions are solely advisory, and the court is not obliged to go along with them. So the Court of Justice provides the final decision in any case. Okay. So you can't have a dissenting judgment in the Court of Justice. They have to make unanimous decisions. So the Single European Act of 1986 created a court of first instance, but it's now called the General Court, according to the Treaty of Lisbon 2007. And things from that General Court can go up to the Court of Justice of the European Union. Okay, there are 3 more institutions. There's the European Council, which is for the heads of state, i.e. prime ministers of all the member states. And it discusses the overall policy of the EU. Where are we going? What's our destiny here? And this garners a lot of media attention. Prime Minister's meeting. Its headquarters is in Brussels, but they have met in various other member state capitals. Then there's the European Central Bank, which is based in Frankfurt. They print the euro, for example. Now, remember, some EU member states are not in the euro, for example, Sweden or Denmark, and several countries which are not in the euro, not in the European Union, use the euro as their currency. Very microstates like Andorra, Monaco, San Marino, the Vatican City, but also places like Montenegro. Anyway, so the European Central Bank, it coordinates matters with the central banks of the various member states and tries to maintain price stability and the Growth and Stability Pact, making sure that people don't have too big a deficit. Then there's a Court of Auditors. It's not a court of law. It's really sort of for accountants, and they audit the revenue and spending of the EU. Its headquarters is in Brussels, but notoriously for years they wouldn't sign off on the EU's own accounts because there's so much corruption, so much waste. So let's look at interpretation and the enforcement of EU law. This is mostly up to the EU courts. So an individual can bring an action to the Court of Justice for the European Union and the General Court only if he's contesting the validity of the acts of the EU itself, which could also be secondary legislation, and that is pursuant to Article 263 of the TFEU. Or perhaps the institutions of the EU have not acted under the said article as they ought to have done. So the Court of Justice has the right to hear these actions when someone's trying to gain enforcement against a member state. Anyway, so the Court of Justice gets many of its preliminary references from the courts of member states, including England and Wales, but not anymore because it's out. So that's under Article 267 of the TFEU. Anyway, so if a reference is provided to the Court of Justice, as in a complaint really, they rule on this. Anyway, you can't appeal from the court in your member state to the Court of Justice. The only way a case gets there is if the national court decides to hand it on to the Court of Justice. So the European Commission has crucial functions in upholding EU law. For instance, one of these functions is to decide whether a company or a firm or something like that is breaking EU law on competition. It can award fines if people are breaking the law in this regard. And indeed, it can bring an action to enforce a law in the Court of Justice against a member state of the EU which is not adhering to its obligations under European law. So let's look at the European Convention on Human Rights. Now that's different from the EU. It's a huge misconception. It's not an EU thing. Anyway, so it came into force in the United Kingdom in 1953. The UK was one of the first countries to sign. The convention was not part of UK law until 1998. So only in 1966 were people in the UK allowed to petition the European Court of Human Rights, claiming their rights had been breached. So the Human Rights Act of 1998 incorporated the convention rights into British law. So that's not just for England, Wales, the whole UK. So Section 6 of the same Act said that there is a legal obligation on public authorities not to behave in a manner which is incompatible with the convention rights. And that's for all public bodies exercising public functions. However, it doesn't extend to Parliament, oddly. So anyway, under Section 6 of the European Convention on Human Rights, so those who are the victim of a public authority which has not adhered to its obligations under the European Convention on Human Rights can start a case in a court to try to make sure that their rights are upheld or to be granted a remedy. And you can use your convention rights, for instance, when you're defending a legal action. So in Section 3, it says that a court or any similar body is behoven to interpret legislation in a fashion which is, in as much as possible, compatible with the convention rights. Sometimes it can't, and therefore they have to make a declaration of incompatibility under Section 4 of the European Convention on Human Rights. And this says that this particular piece of legislation is repugnant to the Convention on Human Rights, but then it's up to the government, well, to Parliament really, to decide whether they're going to change the pertinent piece of legislation or not. The declaration does not make that law invalid. Then look at Section 2 of the Human Rights Act 1998, which says that in deciding whether a question touching the convention right, a court or a tribunal must consider any decision made by the European Court of Human Rights or some other human rights bodies. So the European Court of Human Rights is yet another source of law, and is very meaningful because it has interpreted these convention rights as in rights arising from the European Convention on Human Rights. So many of these rights are in negative terms. The state is not allowed to do whatever, not allowed to torture, for instance. But the court has also come up with a notion of positive obligations. It's insufficient for a state to meet its negative obligation of not torturing, for instance. It must do things, it must forbid and discourage and indeed penalize violations of the rights by others. So that's just a little bit about European law. Okay, toodaloo.